Welcome everyone to tonight's seminar hosted by the Transnational Legal History Group, part of the Center for Comparative and Transnational Law here at CUHK Law. One second, just let me check something. Tonight's seminar will be on the subject of the history of international law and China, Eurocentrism, multinormativity, and the politics of history. Our presenter tonight is Professor Maria Adele Carrai, who we are immensely fortunate to have with us. She is joining us from Europe tonight, although she is no stranger to Hong Kong, having spent many happy years here in Hong Kong in the past. Professor Carrai will speak for around 40 minutes. After that, we will open up the floor to questions and discussion. If you do have any questions during the talk, please just send me a text message. Send me your question if you can. And then following the talk, I will read out the questions or, probably in fact will also give you the opportunity to turn on your cameras, unmute yourselves, and present your questions directly so we can have a bit more of an engaged back and forth discussion. It's always the case in these talks online that questions come in rather late. So if you want to make sure you get your question in there, just let me know early on during the talk that you have one, and I'll add you to the queue. Okay, so that's it from me here at the beginning. Without further ado, let me hand over the floor to Professor Carrai.
Thank you, Chris. It's great to see you again after all these years. So thank you for having me. It's great to be back, although just virtually in Hong Kong. Today I'm going to talk about the history of international law and the way it has been constructed, some of the issues, some of the main trends of historiographies, their limitations, and the politics of history behind that. So it's not really a presentation of the history of international and China, but rather how history has been constructed and why it matters today. But I would like to start by sharing my my PowerPoint. Okay, so slideshow from the start. Okay, and so I would like to start with this image. I don't know whether some of you have seen it. It became quite viral on Chinese social media, and it was also reported in some of the Western media. And we see here a cartoon that is entitled "The Last G7." And so, of course, we see that is evoking the Last Supper, but instead of Jesus, we have America at the center, and then all the other G7 powers that are sitting at the table, and they are deciding the future of the world. And this cartoon was made by a Chinese artist, and it evokes the past in a way. And I want to show you these other cartoons that were of the end of the 19th century, beginning of 20th century. And of the left, we have the cartoon where China is cut, right? At the table again, we have foreign powers that are deciding the future of China in the world. And then the other image on the right has animal, because it's something that it repeats itself, right? And we see it's a bit not clear the image on the right, but we see China that has no identity, no animal represents China, that is occupied by Western powers depicted as animals. So we have the bear that represents Russia, the dog, the British Empire, the eagle on the right. I don't know whether you can see that represent America. And I think that like history continues to matter today, and also from the Western side. So I want to look at like if you open major news, China is depicted always, not always, but like very often as an exception, as a country that doesn't abide the rules of international law. China is overturning the rule-based international order, and so forth. And I decided to put an image also like provoking. So this is a provocative kind of thing that hopefully will give us more food for discussion later, food for thought and discussion. About this cartoon, the picture has got to go, right? Where we have the civilization that is represented by this beautiful woman that cut the tail to the Mongol, to the Chinese, to the Manchu, the Qing Empire, and you know, we see all this kind of history that gets back in the rhetoric today. China is portrayed in the also the way the world order was constructed, international society was constructed. And again, we see from the first cartoon, the last G7, how history still weighs very heavy in Chinese understanding of the international politics, the international society. And the same is true, I think, for the West. The way we understand China, the way China continues to be an exception. And if we look at the history, I did in my previous work, the history of the concept of sovereignty in China, we see how the West expanded, and it expanded through international law, and how China has been often considered as the, was given sovereignty from the first Opium War, but then it was always considered uncivilized, not good enough to become to be a proper equal sovereign state in international society. And I can see some legacies today, but in this small lecture, I want to talk about the way histories have been constructed of China and international law. And some of these histories that their limits is like Eurocentrism, basically the idea that the history of international law emerged only in Europe, and then from there it expanded all over the world, including in China. And so everything that China does, in a way, is a result of this Eurocentrism. And then one other issue of the historiographies of international law that has been produced in the past decades is also its teleological approach. So the idea that every single polity has to follow one single path of development. And so in the past, they have to become sovereign state, for instance. And then one other limitations of many of the historiographies of international law in China is legal Orientalism. So the idea that China didn't have any law before, right? So China was a lawless country. And we can see it even today in China's attempts to promote rule of law, that China cannot have a rule of law because it's still kind of lawless. And from the other side of the coin, we also have problems with the way China is now reconstructing the history of international law and of China within international society. And the issues are historical revisionism and censorship, so that some of the parts of the history is completely cut away or distorted. And then there is a strong politicization of history that we can see, for instance, in the idea of China Great Rejuvenation, this idea that has been pushed very much by Xi Jinping about China regaining its rightful place in the world. After all the centuries of humiliation, now it's time for China to re-emerge. And so all the history of China within international society before is read within this cyclicality or teleology, depending how you see it. And today, so I will briefly discuss the different ways history of international law has been constructed, and identify in particular three main trends. One is a way of telling the story of China international law as China encounter with the West. Another one is the global histories of international law. They became very popular in the past decade. And then the history that talks about China's appropriation of international law, that focuses a bit more on the agency of China and Chinese in adopting this law. And then I will conclude by mentioning other ways of looking at history of international law in China, that is legal pluralism and multi-normativities as possible ways, but also the risks involved in this historiographies, if you want. Okay, so let's start with the first method of looking at the history of China with the West and international law, international society. So within these narratives, and there are very many, and there are references. I'm not going to give you all the names. At the end, I will suggest my book and other articles. You can find all the names, but here I'm more interested in what do they say generally. And so in this kind of account, China encounters the West. And the first encounter is considered, this transformative encounter is considered the 1842 Treaty of Nanjing. And from this encounter, China starts to modernize. And we can see a lot of histories that tell the story of China from being an empire, Tianxia, to becoming a guo, a nation. And this this basically, the limits of this is that China participation in international society is only possible through the West. And a lot of this historiography is basically focused on Western sources rather than Chinese sources, or decided to take Chinese sources only in function of Western accounts. Despite the fact that there is a huge material in Chinese that hasn't yet been uncovered. And the politics behind this China encounter with the West is in a way to justify the civilization process of the West that expands, that includes China, and it gradually will include the entire world, or is including now the entire world. But then if you look at this way of telling the history of China with international law, the question is, how do you justify East Asian history before, the history of China before, the history of its multi-normative empires? What about Chinese agency? Because here the history is only the history told from Western perspective, from Western accounts. And what about deviations from this teleology that is very clear also today, at least in part, with China kind of deviating, or also other actors deviating from this this modernization process that is deemed to be universal and inevitable. And this way of telling the story of China encounter with the West has also been politicized partly by China, and that see this Chinese encounter as like a way to modernize, but it was a forced modernization that implies victimization. We hear over and over, I don't know, I'm sure you also did, like the idea of the century of humiliations that ended only in 1949 when Chinese Communist Party took over and funded the PRC. And so here, this kind of historiography can also be politicized by China in a different way, as a way to justify the current power and China retaking its right place in the world after all these years of imperialism from the West. Okay, so the second way to look at China within the history of international law is the recent global history of international law. And here it's important to mention the global turn, and also mentioning Fassbender and Peter's book, Global History of International Law, with Oxford University Press, that came out in 2012. And their goal was trying to go beyond the categories of nation states and focus instead of interconnectedness of all these different experiences. And one way to include, if you want to, this to be global in these histories of international, so not just being limited to the East-West encounter, was, for instance, to discuss the ancient ancient Chinese international law in spring and autumn in China. But the dogma of international law and other history seems a variation of a European grand narrative, because what is looked for in all these other contexts, even in China, is the very idea of like sovereignty, treaties, that is relevant for international. So it's still kind of limited. And what is the politics behind this global turn? I think the politics is a legitimization of a cognitive horizon that seems to have become universal in the course of the 20th century. And I think this is represented today by the idea of an international rule of law or rule-based order. From a Chinese perspective, global histories can be seen as a sort of self-orientalization. And the politics behind is the attempt to be recognized within the international society, but also to universalize their own experience. And so the idea, I want to just briefly discuss this spring and autumn international law in China. So this was an idea that came out from Martin, that was a missionary that was an American missionary in China at the end of the 19th century, that for the first time translated systematically international law into Chinese. And so he was the translator, like, you know, he had also other translators helping him, but he translated Wheaton's Element of International Law that was translated as Wang Guogongfa, that became the reference for international law in China from 1864. And the idea was that China already in the 7th century before Christ had its own international law, because it was divided in different states that was at war with each other. There was no superior morality that governed them, and hence the rise of a proto-international law. And this was what Martin was saying, to try to make China, make the Qing Empire more to make the case for China to become a part of international society. But then if we read the Chinese scholars later, at the end of the 19th century and also beginning of 20th century, we see how they use this spring and autumn international law in China as a way to push for Confucianism. So we see how here the history of international law is politicized, not just a way to for China to be recognized within international society, but also as a way to universalize their morals and Confucianism. Then we have the third kind of historiographies and way of doing history of international law in China. And it's the one that focuses on China agency and the appropriation of international law. And we have actually a lot of great Hong Kong scholars that have done that. Billy So, Michael Ng, and in the States, we have Lydia Liu, for instance, that focused on translation and the way Chinese actually understood and manipulated the meaning of these new transplanted international law terms. And also the focus of this new approach to the history of international law in China also focused not just on the appropriation of international law, but also how it has been used and how these Chinese jurists contributed in the course of the 19th and 20th century in particular to the development of international law. And one key contribution, according to some top jurists, Chinese jurists, is a 5 principles of peaceful coexistence, for instance. But there are also other studies that show how Chinese jurists contributed to the League of Nations, some of the key concepts, or to the United Nations as well. And here, international law become kind of politicized as a shield because you can interpret it in different ways. So for instance, even sovereignty, right, that can be relativized so that you can, for instance, intervene in another country in names of human rights, but also it can protect you from others, right, in name of absolute sovereignty, like what China is doing now within its own territory. But the issue with this kind of China agency remains of what was there before, right? How to account the normativities that existed before. And so this, I mean, some of the scholars, of course, discussed that, some others not, but this is a question. And if you want the limitations of the appropriation, can we just appropriate of international law, or can there be something else? Okay. And so here I'm going to briefly discuss instead other approaches that might be kind of fruitful in the future, but again, they have some limitations, as I will discuss in the next slide. So legal pluralism was a term that, or an approach that was particularly developed by the scholar Cassel. And it includes different legal orders, but the problem is that prioritize the law as it is currently understood. And I think here we can go back to also the global turn, right? That like you try to globalize international law and its history, but then what you look for in other experiences is always the same covering the same key terms, the same structures that are relevant today. And so you wonder how really, valuable that can be. Instead, it might be more useful to have these other kind of experiences speak in their own terms rather than in current law terms. And then another approach I think it's quite promising is multinormativity. That is a term that was kind of created by a German legal historian, Duvet, in 2016. And an example I think can be seen in Brooks, Timothy Brook and others' work. And multinormativity allows to explore other modes of normativity that are not necessarily structured around certain notions of law, that is state practice, legal theory, decisions of international courts and tribunals, and really rather focusing on what can be considered as a vernacular law, so a law in its own terms. And I think this can be very interesting also for international relations today, international politics today, right? And this I think can be translated into the idea of multipolarity, right? That there are different countries with different poles of power that have their own normativity. And this was the case also in the past, right? So we broke away with this teleology of history and values, and we focus instead more on multi-normativity. But the problem with this in the case of China is that you end up from a kind of like a centrism to another. So you move from Eurocentrism to Sinocentrism and creating parallel systems. And so the idea that for instance, if you push to the limits, like this idea of multinormativity, China was not peripheral, right? It has its own history of norms. But then the risk is that it becomes that the world was peripheral to China. And I think we can see that very clearly today in what's going on with China, Great Rejuvenation, and even the idea that has been revamped by the scholar, for instance, Zhao Tingyan from 2010, the idea of Tianxia, that China might recreate this Tianxia system, that's been very much criticized by some scholars as a form of new imperialism. And this can also be seen, this rereading of the history can have actually serious repercussion. And we can see in, for instance, scholar Zhao Bingbing and Gao Zhiguo, that try to use the value of ancient relationship between China and other countries, the way China asserted its sovereignty that didn't really, wasn't there a concept that was very important to justify its sovereignty in the South China Sea. And I think it's very important to look at the history of international, how it has been constructed, because it has serious implications also for today. Like, you know, the current international law system, it has been, it's very much, it was born, if you want, in Europe with encounters, if you want, with other reality, with the Americas and so forth. But a lot of the history, it continues to be Eurocentric and some of its practices. And so I think now we have different actors coming in and wanting to try to shape this new kind of international law and world order. And so that's actually will be for me the presentation of today, and it's based on this on my book and an article that is entitled with the same name of the today presentation, History of International Law in China, Eurocentrism, Multinormativity and the Politics of History, that just came out with the Routledge Handbook of Chinese Studies. And yeah, I look forward to your questions and comments. Thank you.
So thank you so much, Adele, for that fascinating talk. And I encourage everyone in the audience to, you know, if you have a question you'd rather I read out, you can send that to me in the chat. Or if you'd like to, you know, turn on your cameras and pose the question yourself. I know sometimes it's hard to get the details out in a chat message, so just send me a message that you would have a question you would like to pose, and we can do that. But to get us started, I will take advantage of the traditional chair's prerogative to ask, you know, what I apologize is sort of quite a broad and open-ended question in many ways, but a very genuine one, because it's you know, so very hard to answer, I'll say in advance, but something I also always struggle with when thinking about this type of question, sort of the history of the politics and the genesis of international law and so forth. And that probably builds on the last point you raised, which you know, pertains to sort of the multi-normativity, was it, of the international legal field. And that is, you know, basically that, or multi-normativity or pluralism, whichever one you want to use. To me, it's always seemed that there's so much pluralism and multi-normativity baked into international law that it's hard to even, you know, we often talk about it as a subject as European, and obviously it's produced there, but it's got so much going on within it. It's hard, I always find it hard to, you know, or I get a bit confused when we talk about international law as the central object of investigation as such. So I mean both that, right, when we talk about international law, there's international economic law, which is doing certain sorts of things. There's human rights law that is doing certain sorts of things. But even within any one order like that, you could find a lot of different perspectives that potentially clash with one another. There's different ways of interpreting freedom of expression to say, you know, alone to say radically different things, or you could contrast sort of communal socioeconomic rights with individual civil and political rights and find a lot of internal tension. within any particular national, and then when we think about, right, even obviously international law is produced by a complex set of states interacting with one another who, and somehow, sometimes there's one that's very, or a few that are very powerful that are able to project their interests. At other times, it's more of a negotiation. But even when one state thinks it's projecting its interests, it might be that 20 years down the line, it turns out it's not so happy about the rules it itself helped to put in place. And then there's the fact that internal to any state, right, there are many different communities who are probably on different sides of a single sort of international law issue. So some would be strongly advocating in favor of, this or that trade agreement, for example, and some would be opposing it because they just have different interests. So as I said, it's sort of a very, apologies because it's a very broad and open-ended question, but it's sort of how do you, knowing that you've thought about this sort of thing for some time, how do you grapple with kind of that sort of internalized pluralism, multinormativity, complexity to a subject like international law?
Yeah, thank you. This is a great question. And international law is complex, right? There are clashing, like multiple kind of international laws. Even today, there isn't such thing as the international law in a box, and that's it. It's constantly produced and reproduced by different actors. There are stakeholders within the state that shapes international law. But in this presentation today, I think I was more interested in the way its history has been constructed. And of course, like when you construct a history, and I think one of the limitations is that you have to simplify, right? All the complexity to make it legible. The history of international law, you have to greatly simplify the world, right? You have to focus just on some elements. Otherwise, you cannot really write about something, right? And you have to start from somewhere. And that's why, for instance, in the book that I wrote, I focused on sovereignty, right, as one aspect of international law. But yeah, that said, it's the complexity. I think that the multinormativity or plurality wants to probably emphasize this aspect of complexity and diversity of orders and norms, because once you read about it, right, the canons of international law, it's actually quite limited in the way to understand this complex reality. And again, it's part of the job. Also, when you do history or so, you cannot just tell everything, but like you have to select certain aspects. And what is international law? So now I'm co-editing a volume on the history of international law in Asia, from the ancient time to the present. And it's extremely challenging, right? Because what do you look at, right? And in the past, how different polities related to themselves and to others, and try to have them speak again in their own terms rather than imposing certain aspects. And again, there is economic law, there is diplomacy, there's so many different aspects that you can discuss. And today, I think probably was a bit abstract, my talk. And if you go more into the readings or the articles, there's like more references. Probably today it was, I should have brought more specific examples about international law. And again, it's really more a reflection on how the history is done. And of course, like it brings to the question, what is international law to start with? And it's something that is very complex, and I agree with you, Chris. And one should always keep it in mind when writing histories of it. Yeah.
No, absolutely. Thanks very much for that answer, which I think also helped me to think about some of the underlying struggles that I have with some of the same questions. So let me again see if anyone in our audience tonight, if you have any questions to pose, please send me a message. Otherwise, I will take the opportunity to follow up on another thread that is, connected in a way, and again, of sort of my own particular interest, which is, I think you mentioned at one point towards the end of the talk, the something of the encounter with the Americas, for example, as an issue within sort of helping to generate international law as a field in Europe and so forth. And I guess, I think that the whole question of, right, on the one hand, we can say in the first place that sort of there's some kind of European genesis of international law, whatever that means. But also, it's not just, then there's a secondary question, which is to what extent is that something that's happening in Europe as kind of an isolated blob in the world region? To what extent is that something that is happening specifically in and through the sort of project of European imperialism, colonialism, and kind of venturing around the world, and with Grotius, for example, just so obviously, for instance, so obviously writing in response to this kind of transnational dissemination of merchant endeavor, etc. So if you had any thoughts on that specifically as well, right? So how the kind of Eurocentrism of international law, or sort of historic European, sort of connected nature of it, is one part of it, but another part of it is that the rules that developed somehow were generated out of kind of the history of colonialism as well.
Yeah, no, it's a great point. And it is international law in a way, it's relational. Its genesis is relational, because if there wasn't another, polity to relate to, there would have not been probably an international law. There would be no need for international law. The Eurocentrism, though, is the way it is narrated, right? If you read like some of this history, is always reads as if it was born in Europe, right? As a product of Europe. And also the way it was practiced in a way. And it's clear also when you look at the history of sovereignty in the expansion of sovereignty, like, it was European, but like China was outside, or many other countries were protectorate, like were semi-sovereign, and who decided were the Western powers. And so you have this kind of Eurocentrism, and also some of the norms, if you want, they were relational in the sense that like the international law emerged as many encounters as well, and like the other party also affected the development, but there are some parts, like some kind of words and concepts that come from Europe, if you want. And again, the way it is narrated, is constructed, is often very Eurocentric. And again, even in China, it is, if you look at like previous history of international law, was the results of kind of the West. The materials that were consulted very often were about Western diplomats, how they see things, rather than how China saw things, how China or Chinese diplomat jurists appropriated things, saw things, understood international law, contributed to it. So in that sense, it's kind of has been Eurocentric and linear. Like there was also this idea that this imposition, if you want, of civilization, where everything that was not conformed to like this civility values was barbarian, and this idea of progress, of modernity, right? That every experience has to conform with the one of sovereign states, right? And so forth. That is challenged partly today. I mean, it's true that we are in a world of sovereign states. I think there are few. Yeah, I think pretty much like we're a world made of sovereign states, right? Yeah.
Right. There's a few. The Vatican City still has a UN observer status or something, but not many.
Yeah.
such.
But overall, I mean, you definitely have exceptions, right? But pretty much, I mean, it was quite successful, this idea of like, you know, the structure of international society. And yeah.
Great, thanks so much. So I note you said all research is driven by your own values and the perspectives of the present. And that is, of course, true of most people's research, but mine, of course, is driven by timeless, objective questions. So I just like that on the record. But we have another question from the audience here. So Joel Slowatsky says, excellent presentation. And asks, the historical narrative you eloquently outlined showed that the Eurocentric narrative was not overly friendly to China, given, for example, the justification of the wars to liberate ports, to open up ports and so forth. And asks as well, in your opinion, can a Chinese version of international law serve the interests of China, given sort of the way that international law has been shaped?
Yeah, it served greatly China in the past decades, I think. And I mean, you talk. This person means the present or the past? I mean, I think.
Yes, sorry. In the present, I think, and he also asks your opinion on China's view of China's neighbors. I think following up on one of the themes Ryan brought up concerning the kind of barbaric question.
Yeah. So yeah, I think that I mean, it's not just I think, but if you look at the past decades or so, the international law has served China more than harmed it, and I think China integrated within the various international legal regimes. The only probably exceptions was partly human rights. The human rights regimes, but also for that, like it became part of its discourse, human rights. So that's kind of positive, from going from basically being an outsider to still to at least you know, signing some of the covenants of rights, and also economically. I mean, joining the WTO and like, you know, all the globalization, I think it was quite helpful for it, and even the promotion of international law within its discourse right now. So it's I think it benefits from it. And in terms of China neighbors, what can be, like, could you specify more the questions about like the China neighbors, like what aspects of China neighbors, how does China sees its neighbors?
Or yes, and this the question is to get your opinion on, you know, to what extent China sees its neighbors through this sort of civilized barbaric versus barbarian framework.
Yeah.
In the past.
In the past, so in the present, I mean, I think now it's a bit different, but like, of course, like this revamp of the tribute system where China is at the center, and dispel kind of civilization to the rest, right? China is a model. You know, you can see some legacy of the Hawaii kind of concept, but not really. They will never talk in these terms, probably, at least officially, that we are the civilized and the other one are the barbarians. But I think there is still some of this thinking, and also racism, if you want. And now also with the US-China trade war, I think that there is more kind of looking down at also the West, also from the financial crisis, that China kind of did well while the rest of the world wasn't really recovering. I think gave China even more strength in its view of itself, right? That's like taking the right place in the world, that is the central place in the world, that has a bit of of this kind of we are the more civilized, and and we bring kind of peace and civilization to the rest of the world. But of course, it will never formalize this kind of China new centrality in terms of Fai, like civilized and barbarians. But I can say a bit of legacy also because it promotes constantly win-win cooperation, equal sovereignty. We're all equal. So it will never kind of use that in a formal context.
Right. Yeah, this is my own interjection here, but there's an interesting sort of, I guess, something you can see with China, but you can see with every country in terms of international law, where sometimes a state sees itself as benefiting from being on one side of making a particular international law argument, and they sort of push very hard in that direction because they, it fits their global geopolitical position at that point in time, and then 20 years down the line, the power balance has shifted or something like that, and they find, oh no, actually this is being used against us, or we now want to do exactly the opposite.
Yeah, look also the US, right? I think the US is also a case in place where, like, I think that there's so much kind of power behind the international law, the use of international law, the acceptance of international law, and it's possible that in the future also China will change its approach to international rules, because so far, and there is a great article by Ian Johnson at Harvard University that analyzed in a almost scientific, like as a political scientist, so like he really did an analysis and quantify things about China participations in different international legal regime, human rights, economic, United Nations, environmental, and he found out that China has been pretty much obeying international law, like these different kind of regimes. But this might change in the future as it becomes more powerful. So there's nothing that is really safe. But look also the America, right? That was part of one of the countries that really wrote the rules, but then disobeyed them when it was convenient to do so.
Right, or specifically sort of, right, post-World War II wrote the rules for everybody else, never even imagining that they would conceivably be bound by those same rules.
Yeah, exactly.
Yeah, no, really interesting stuff. So another question from the audience, from Maria Orzel, is sort of related to some of these themes. So she asks, China joined the WTO, but yet in that context has continued to violate most of the agreed terms. This has nothing to do with Eurocentrism. Does it mean China just wants things their way and refuses to follow the rules in general?
Yeah, I also think that each country in a way wants things its way, but then it depends whether it has power to do that, and also like whether it, of course, it obeys its rules. But there are also studies that shows how China actually did not disregard that much the WTO rules. I mean, and it's very often portrayed as such, but I think one of the last conferences I attended from a professor at Columbia University that wrote a book about China and the WTO. I mean, I'm not an expert, so I don't know, but like it's less kind of the bad guy than what it is often portrayed. But of course, it wants the things in the way it wants, and it will try to do that. But I think within the limits of international law. I mean, I don't. Besides, like I think the South China Sea that disregard the award of the South China Sea, but I mean that's also but overall, I think that it tries to respect even the United Nations. Like it's trying to staffing the UN, but it's still less than other powers to influence the United Nations the way it functions. But it's still pretty much following those rules. I think it's not going to start a war in the Middle East or elsewhere without support from the Security Council, for instance.
Yeah, brilliant. Thank you. So I have no further questions from the audience at the moment. If you do have one still that hasn't been addressed, let me know. I'll ask a final question of my own, however, as well, that kind of another thing that your presentation really brought to my mind, that again, I don't have a clear sense of how to deal with, but I think as scholars of international law, we encounter a lot, which is sort of and was particularly invoked, for example, you spoke about thinking about the history of international law going back, backwards in time, I think especially before the early modern era, when you start to have texts that are saying more explicitly they're doing something like the law of nations or what have you. And that is sort of the relationship between if we're doing the history of international law, do we do the history of scholars talking about international law as it were, or do we do the history somehow of the sort of power relations between nations? And what is the kind of the relationship between those two things, right? Because international, somehow there's one component of international law as a field is almost this attempt of scholars or judges or jurists, etc., to, there's some sort of at least self-imagination of we are this, there's something progressive built into this whole project, and we're imposing these rules, over states, and by doing so, we will achieve a more sort of just or peaceful or rights-respecting world. So there's this kind of project of, sort of being able to take ideas and to layer them directly onto the world in a way that will influence it. And there's an open question to it, right? I mean, there's, I guess, a lot of open questions around, is that ever really effective? Obviously, states can use those terms and all the rest of it as well. They have quite a bit of influence there. How the different camps relate to one another is an open question. And there's also a question of even, to the extent we're focusing on the rules that are created sort of under the heading of international law, a lot of the time they're not necessarily greatly followed in reality. So is it just a distraction from sort of the real kind of power relationships, economic relationships, etc., that govern the world? So again, that's apologies, because again, that's a very broad and open-ended question, but kind of the relationship between sort of, how I mean, even just from the perspective of how to do the history of this sort of thing, right? To what extent are we looking for sort of texts by scholars who focus on these types of themes? To what extent is it about just looking at kind of how sovereigns and states and rulers and armies kind of interact with one another?
So thank you. These are all great questions, and so in terms of like how do we do history of international law? I mean, international law as a field and as a discipline is something quite recent. So the question is like, how do you do a history of international law going back in time, right? 2000 years ago. And for me, so there was not even a text or scholars that discussed international law, not even like in Europe, right? It didn't really exist as we know it today as a discipline and as a field. And so going back in time, I think the best would be to just try to focus on the kind of relationship that different polities had within themselves, because there was not even a sovereign states, if you want, as we know it today. And so it was very much complex, the kind of relationship. Even China had like so many different ethnic groups, empires, but like it was quite very complex kind of stories. And so look at the norms that they used to conduct diplomacy, to wage war, to make peace. This kind of aspect of relationships. And what else I wanted to say? How do we do history? And is not just power relations. I think it would be too cynical to just say, okay, international law is just a distraction from real power relations. I think that there is, and it constrains, it guides states' behaviors. But of course, there are power relations there. And so sometimes strong powers decide not to abide those rules, but definitely they serve as a kind of guidance of action within international society as we know it today, and they used to guide the polities in societies that were not really international, because the world was very limited within their own kind of geographical margins back in time. But you definitely had rules for how to make peace, how to make war, how to conduct diplomatic exchanges, also in other polities in Asia and the Chinese empires. Yeah.
Okay, brilliant. Thanks so much for that answer to my question, and for all of your answers to all of the questions posed tonight. I'm sure of course, everybody I think is forcibly muted by the Zoom preference auto settings, but I'm sure they would otherwise all join me in thanking you so much for being here with us and for sharing this fascinating and thought-provoking presentation. I'm sure we could, keep debating some of the kind of historical and ideational issues for some time, and doubtless will continue to do so in future. But in the meantime, thank you so much once again for being here with us. We hope to be able to see you in person one of these days, and I see thanks coming in from the audience members as well.